they can allow us to do it. That we're still covered, under your for holding open houses for a builder. It's a weird sort of area just because they're not a brokerage. So,
Okay, but most of them list on the MLS.
yep, if they do, then we're kind of that's
Through,
SOL. Yep,
yeah, through the bigger.
brokerages. Yep. Although we're number 10 right now, so we're moving up. Here we go.
Yes, we are.
Where? In Houston or where?
No, that's nationwide. We're number 10.
Nationwide.
Yeah. And so we're moving, but yeah, in Houston, we're one of the larger firms, so which is great. One of the top 5, I think it is, in the Houston area. So, okay, let's get started. Welcome again to Forms Friday or Friday Forms, whatever. I always get the two reversed. It is Forms Friday, even though the emphasis says Friday Forms. So, Don and Raul are here, and myself. Thank you for making time on Friday morning. As always, these are recorded. They're restored in a playlist on your Real Smart Agent portal under education, under video courses. The most recent one is the one you see first. Click on it. And then there's a playlist. You can scroll down to the one you want. And I'm trying to label each of these by the form name. So today it will be, of course, the buyer's notice of termination and the seller's notice of termination and the release of earnest money. And this should be a good conversation around these forms today. The forms themselves aren't huge, but they have a lot of information and they're tied to different contract pieces, which we're going to kind of go back and forth on those screens today. And obviously, Raul and Don, feel free to jump in anytime to expound upon anything I say. But I figured we've gone through most of the major forms as far as the contract. We'll do more listing stuff. Raul's going to do on letter of intent next week. But we're getting kind of these type of things where we've done some of the major addendums as well. And so now we're looking at what happens if the buyer wants to terminate or can terminate, and when the seller wants to terminate, which is much rarer. They always want to, but their options to terminate are limited. And we're going to talk about where that is in the contract that gives them the right to terminate in the form itself. And then the completely separate discussion around release of earnest money. How it works in Texas. And this might be a long discussion or just a short one. But there is, no, even though the buyer or may have the right to it, doesn't mean they get it. And that is the biggest thing that we need to make sure we convey to you. There is no guarantees. Even in a contract says you get A for B and so forth. That's still not a guarantee. It's an agreement. But both parties have to perform. So we are getting started. All right. So last week, which I need to watch it, but Don did the amendment to the contract. I heard it was fantastic, as always, Don. I'm going to go back and watch the replay of that. Again, that's not one of those forms where we use it for just about anything to change the contract. You have an executed contract and you need to amend it. You need to make a change, and knowing how to use that and where to use it and where you have the contractual right to use it. But even that form, as I'm sure Don covered last week, it's not something that once you fill it out and send it, that they have to agree to it. It's a request to amend, to change the contract. So all parties have to agree to it. Right, Don?
Yes, sir.
All right. So today, like I said, we're covering 3 forms. Again, it's around the same things. When does the buyer have the right to terminate the contract? And when does the seller have the right? And of course, when they've either side has terminated the contract is done, and there's earnest money sitting in escrow or in title, and how do you make a demand on it, basically? Okay. So that is the TREC form 38A, TXR 1902. Of course, it's TREC form 50-0 or 1950. And of course, there's only a Texas Realtor form for the release of earnest money. Interesting to me that TREC doesn't have one of those forms, right? That doesn't in one fashion or another. All right. So the first one, of course, is the notice of buyer's termination of contract. I have this in 2 forms. I have it in the slide deck and in the actual form itself. I figured we cover the first 3 to the form and then go through the last options there. When it says the notice of buyer's termination of contract, okay, concerning the property at this address between the buyer and the seller. Now, it's between the buyer and the seller. You put the seller's name, right? And the buyer's name and the seller's name there, because this is the buyer giving notice to the seller that, hey, based on my contractual rights, the contingencies that I built into the contract that are there naturally or were added through addendum, I have the right to terminate. I'm giving you notice that I'm exercising that right in the contract. So the first three are pretty straightforward. First one is your unrestricted right of buyer to terminate the contract under paragraph 5 of the contract. Okay, let's pop over and look at paragraph 5 of the contract. I believe it's this one. Make sure first. Nope, hold on here. There we go. I'm going to share this one. Make sure you see it. Got it? There you go. So paragraph 5, right? This is our earnest money paragraph, right? And so then right down below that is a termination paragraph, which is the option period. So paragraph B says, for nominal consideration, the receipt of which seller acknowledges and buyer's agreement to pay the option fee within time required. Seller grants buyer the unrestricted right to terminate its contract by giving notice of termination to the seller within blank days after the effective date. Of course, it has to be done by 5 p.m. on the day. We all know this, but this is where this form that we're looking at right now gives us the right. So in the contract, we've negotiated a period of time for a nominal fee that the buyer can give notice, as long as by the deadline, 5 p.m. on the last day, make sure you know your contract days, that we're going to check box 1 and say, hey, seller, you gave us this right. We negotiated this. We paid our option fee money to title and escrow time so that we have this is still in place. So we're going to exercise our right to terminate the contract. And in the language of the contract itself, it says if we do so and we send written notice within the proper timeline, then the earnest money is returned to the buyer. Okay, this is our cleanest way out, right? Again, this is one of those things where we've given notice to the seller. Seller sees, oh yeah, I give you that contractual right. You did pay the option fee. Contractually, the buyers do the earnest money. Deal's done. Okay. Option number 2. This goes back to, says buyer cannot obtain buyer approval in accordance with a third-party financing addendum. And the contract, the buyer has delivered to the seller's lender written statement setting forth the reasons for the lender's determination. Okay, this is buyer loan approval. And number 3, I'm going to do them both together. Number 3 says the property does not satisfy property approval in accordance with a third-party financing addendum to the contract. Buyer has delivered to the seller's lender written statement setting forth the reasons for the lender's determination. Okay, so options 2 and 3 for the buyer to terminate only applies if they included a third-party financing addendum in their contract. I know it seems like rocket science, but think about this for a second. If they don't include it, then you can't use these, in your contract. Hold on here. I'm going to go over to that form. When the computer speeds up anyway. There it is. Share that with you guys. So third party, we know this is on page 2. This on page 2. Well, now I guess it's not. Now it's on page 1. Approval of financing. Going into page 2 with A, the contract is contingent on the buyer getting approval, and along with that comes paragraph B, which means the property has to be approved. We know in paragraph A, it gives a certain amount of time for the buyer to be approved. That's that contingency period we built in. So it's 21 days, 15 days, 30 days, 400 days, whatever it may be that you negotiated for the buyer to get loan approval, meaning the buyer's approved. Their credit, their income, their assets, they're qualified to buy or to get financed for a loan at that particular amount. Paragraph B, though, is the property insurable? Is it appraised for the certain amount they're paying for it? Any other reason, would the lender actually loan money on that particular property? And we know this contingency goes all the way to 3 days prior to closing. So you have 2 different dates that you have to be aware of in the contract that you've added this addendum to be able to use 2 or option 3 of get out of jail free card. So you go back over here on this one. So if you're going to use 2 on the third party addendum, you have to do so within the timeline you've allowed. So if you said 21 days, make sure you know your timeline. And before the 21st day, you send over checkbox number 2 with a letter from the lender explaining that the buyer did not qualify for the loan and the reason why. That you have to send it together. Otherwise, you're not complying with the contract. Or You've gone past that now, and for some reason the appraisal doesn't come in, or there's not insurable, or there's the loan won't go because there's too much damage to the property, whatever it may be. Then you have option 3. And that's one where you have the evidence. Now you have to provide that as well. Checking box 3, sending it to the lender 3 days prior to closing, at least. Don't mess that. We've seen this a lot. Don and I have, and Raul too, is where a buyer wants to terminate based on property condition, but it's the day before closing. You've missed the window. So oftentimes you'll see a buyer agent and buyer try to extend and get an extension to the closing date so that they can use this addendum, this termination, if you will. So be aware of that on the listing side as well. Okay, so options 1, your unrestricted right to terminate based on your option period, which the buyer paid for and delivered the option money in time. Option 2 is when the buyer actually included a third-party financing addendum, and then within that timeline that they put in the contract, within the addendum itself, they get denied by the lender and provide a lender letter of denial and deliver this to the seller in that time period. Option 3 is when the property doesn't get approved and the seller has denied, the lender has denied the loan based on the property, and the buyer and buyer's agent deliver this to the seller before 3 days before closing. Okay, 1, 2, and 3. Those are all tied to contingencies either added to or included in the contract. All right, it's going up to the next one. So we have 4, 5, 6, and 7, and 8. Okay, there's other ways for the buyer to terminate. Number 4, buyer elects to terminate under paragraph A of the addendum for the property subject to mandatory membership in the Property Owners Association. So it's part of an HOA. And we included the mandatory ownership of HOA addendum in our offer, and the seller has agreed to it. Okay, so I'm gonna go over here. There we go. No, that's not it. There we go. Share this one. And we can see this is the addendum that we added to the contract. And it says under this, right, that we are using our right to terminate based on this addendum that gives us the right, right? And so it says within, so if you're doing A, either A, 1, 2, or 3, or 4, obviously 4, we've talked about this before, where that's where they don't want any information. But any of these other things, it says buyer, it says if they find something they don't agree with in this, and in A2 says within 3 days they can terminate the deal. Same thing up there as well. So using this addendum, and someone needs to mute. I got you. Good. All right. So if we're going to use line 4, we need to make sure that we have included the actual addendum for the property subject to mandatory membership. Makes sense. Okay. If we didn't include it, we can't get out this way. And there's a timeline built into that form on not only receipt of documents, but when we can actually terminate based on after we receive them. Okay. Pretty clear? The next one, the buyer elects to terminate under paragraph 7B2 of the contract relating to the seller's disclosure notice. Okay. We're going back to the 1 to 4 family and saying, all right, well, where is that in the 1 to 4 family? So I'm going to share this one. So it says 7B2, right? So we're down here. 7. There's title, survey, condition. All right there. So seller's disclosure, right? Acceptance, property condition, buyer's acceptance. I'm making you dizzy here. Hold on. There you go. Right there. Seller 7B2. So if you got this in your contract, you do. It says buyer has received notice, buyer has not received notice. On that 7B2 is when you've signed around the contract and you haven't received your seller disclosure notice, and the seller must deliver it to you. It has a built-in timeline for once you do receive it for the buyer to terminate. So now this is your other option. This happens pretty early, and typically they have 7 days. Let's say they deliver it on day 2. Well, you have 7 days once you get delivery to terminate the contract based on this. So each one of these options for the buyer to terminate are limited in time. And there we go. Okay. Now we've covered different addendums and the option for the buyer to terminate. Okay. Then we go into one of Don's favorites here, number 6. It says buyer elects to terminate under paragraph 3 of the addendum concerning the right to terminate. Okay. Paragraph 3 of the addendum. So you've included an appraisal addendum, basically, additionally for this. We'll take a look at that. I believe it's over here. Yep. So it says paragraph 3. So what does paragraph 3 say? Oh, the additional right to terminate, right? It's not the waiver of the termination based on appraisal. It's the bottom one. It says additional rights, in addition to buyer's right to terminate under paragraph 2B of the third party financing addendum, buyer may terminate the contract within blank days after the effective date if the appraisal value according to the appraisal obtained by the buyer is less than X amount. And then buyer delivers a copy of the appraisal to the seller. So you have a timeline to get the appraisal and to when it comes in low, and to deliver a copy of the appraisal and the notice to the seller in time to terminate based on this additional thing. And oh, by the way, you can't just have this addendum. You have to have the third party finance addendum in addition to this included to your contract. We've seen contracts come through with just this and not have a third party. Well, they're tied together. So make sure that you're including the correct addenda and watching your timelines, and so you can protect your buyer. Okay. So, and then of course, the number 7 says buyer elects to terminate under paragraph 6D of the contract. 6C for residential condos because timely objections were not cured by end of the cure period. What are we referring to? We're referring to the title report, right? And any objections we may have in it. So you have to be, where's that at? So we'll go over here and look at right there. Nope. There's too many forms there, Don. So we're looking up here on 6. I'm not sure why they do the 6 after 7, but here we go. And so you have objections in here. You have the title report will not be amended, commitment. And right here, paragraph D. Buyer may object in writing to defects, exceptions, or encumbrances of the title disclosed on the survey other than item 6A1 through 7 above, disclosed in the commitment other than item 6A, which prohibit the following use of blank. Buyer must object earlier of the closing date or blank days. Again, you're tied to a timeline that you put in the contract for the buyer to use this provision to get out of it. And this is varies by state as well. But again, everything one of these ways are scripted by the offer that's been accepted, written by the buyer and buyer's agent, accepted by the seller and seller's agent to allow you to terminate. This is the one that gets us in trouble. Sorry. Is 8 says other, but you see the follow pattern here, right? Other says identify the number of contract or the addendum, okay? The paragraph number. So is it written anywhere in the contract with a number tied to it, meaning is it a clause or a contingency, or is it attached to an amendment, addendum in the contract? Did you add an addendum that referred to another place where it gives the buyer the right to terminate? Then you have to reference that paragraph, name and number, where it shows that the buyer has been given and agreed to by the seller to terminate the contract. And usually it's tied, like all the rest of these, to a timeline. How many days, and when does it have to be delivered, and what has to be delivered with it. We see all too many times people just writing stuff. Buyer no longer wants to buy. Well, that's not in the contract. There's nowhere in there that says that they change their mind, they can get out of it, right? You can't create language or something that isn't already in the contract. You can't use a contingency or a termination notice to trigger a termination of the contract unless it's already been agreed upon up front. There are rules to the game. We've agreed upon these 6, 5, 4, 10 things that the buyer can do at their due diligence. And if those things are not done or not to the buyer's satisfaction, those are the reasons the buyer can walk away. Any other thing is not allowed. Okay, the buyer is in default, and we know the default paragraph allows the seller 3 different remedies. 1, they can take their earnest money and walk away. 2, they can sue for damages for time off market and expenses and so forth, or they can sue for performance. So that is in the seller's hands for those things. So on the buyer's notice of termination, we want to make sure that we're looking at this up front. When we're writing our contract, we understand that we're adding the appropriate addendums and looking at timelines and knowing that we should have this almost side by side as we're going through the contract, going through the transaction, what our timelines for termination for each one. When does this form become where we can't use it anymore? Right. And obviously 3 days prior to closing, if we have a third party financing and it's a property approval, but timelines start at execution. So you have day 0, day 1, and so forth. So your option period is usually your first, but it may be your seller disclosure. It may be the title commitment. It may be HOA documents, depending on what dates you put in the contract, and know when's the next opportunity or when's that window for the opportunity for the buyer to terminate based on that contingency close. Carolina.
Yes, hello.
Do you have a question?
Yes, it is regarding Amendment 6. What if we are using a waiver?
Any questions on this particular form? Obviously, we use this probably more than any of us would like to use it, but I see a lot of misuse of the termination form, a misunderstanding, if you will. So every one of these opportunities for the buyer to terminate is built into the contract. So make sure that we are the professionals and use it appropriately. All right, Don, Raul, anything on this?
Yes, I wanted to add.
Raul, you're muted, buddy.
Oh, am I?
No, he's not.
Okay.
Maybe you can't hear him, but we can hear him.
Can you hear me now? No.
My speaker messing up again? Yeah, okay. I can't hear you. Don, go ahead and answer him if you can.
Okay.
Oh, I can hear now. Good. What did you say, Raul?
Oh, yes. Good morning. On number 6, I think when it opens that kind of when it comes to protecting our client, if we represent the buyer, in a way where if you do let's say an analysis, compared to market analysis before submitting the offer, and of course the offer is going to be pretty much at a higher price just because the sell price of the house is higher, and then you throw in that right to terminate to protect your client, and then again, if for any reason it doesn't appraise and it's no negotiation come to be done, you can always do this buyer's termination or notice of buyer's termination, but then submit this in a way this kind of document proof that that appraisal didn't come at what is supposed to come, right?
Yep, you have to supply the
appraisal.
Yeah, copy of the appraisal, and obviously terminate within the time period you've allowed for it. Yep. Good. And on that note too, make sure it's the right type of appraisal.
Yeah.
So,
Sometimes they try that like a rebuttal in a way. It doesn't go through, but you're doing it whatever it takes to make it happen. So this notice of buyers always along with the proper documents to properly get your earnest money back if that will be the case.
mm-hmm. That's right. You got to watch this. This is on us as agents to communicate with our buyers that, hey, if you are wanting to determine, not that you want to, but your timeline for your option periods at this time, your timeline for your title reviews this time, your timeline for your right to terminate based on a appraisal this time, and now that's gone. That window's closed. Just so you're aware, and we're communicating on a regular basis with our clients so they know that we're watching out for them. It shows credibility as well. Cheryl, questions?
Yes, Marty. I have a listing that is I'm representing the seller. We're having trouble with the closing for the title commitment. So the buyer who's unrepresented wants to terminate the contract. Which option would that be?
Based on the title report?
Yeah, because we're not able to get the title commitment.
Yeah, that paragraph 7. Yeah.
Paragraph 7, okay.
Yeah. That's number 7. Sorry. Number 7 reduced to paragraph 6D, right, Ron?
Yes, sir.
Yeah.
Okay, thank you.
You're welcome. All right. Now we're going on to the second form. Of course, this is when the seller's right to terminate. Now, there's too many times I've been seeing a lot lately where a seller just doesn't want to sell anymore. Well, that's not in the contract. So unfortunately, that's not their right. And sometimes they won't show up to closing. They don't want to sign, and we get all that stuff. Then it gives the buyer's rights during the default paragraph as well. But when does the seller actually have the right to terminate? Well, there's two. And there's the two of them are there is blank, but we'll talk about this for a second. Seller notifies buyer the contract is terminated pursuant to the following. The first one is a window that closes. The first one is when the buyer did not deliver earnest money. Okay. Let's say earnest money is due on the third day, which it is, and it's not there other than the end of the third day. That opens up a window for the seller to say, hey, you're now in breach of contract. I now, as a seller, have the right to terminate because you haven't done what you're supposed to do by delivering earnest money on time. The next day, the earnest money shows up, that window closes. The seller can no longer terminate based on non-delivery earnest money because that breach is now being closed. Okay, so as long as that window is open where it's not in title, it's not been delivered on time, and it's not been delivered yet, the seller can exercise their right to terminate the contract using this form, option 1. However, once that earnest money is deposited with title and the seller hasn't terminated yet, their right to terminate disappears. It's like, poof, you can't use it no more. Okay, that's different than the option money. Option 2, it says identify the paragraph number of the contract. Just like in the buyer's notice of termination, was there something in the contract written in as a contingency or an addendum added of any way, shape, or form by an attorney or one of our promulgated forms that gives the seller the right to terminate? And generally the answer is no. The only other way the seller can terminate is when the buyer doesn't perform. What does that mean? You come to closing and a closing day and they show up and the seller's ready to perform and the buyer is not. And there's no extensions, there's no amendments to the contract, and the buyer just misses closing, then they're in default again. And then the seller can say, all right, no redos, no extensions, we're terminated, and I'm going after your earnest money, I'm suing you for damages, or I'm suing you for performance, But generally, those are the two reasons the seller can do it. The first reason is a time-based reason. If that earnest money comes in opportunity gone. The other one is they had to wait all the way through to closing date and go, all right, the buyer's not doing what they're supposed to do. They're not applying for a loan. There are always things that are probably in breach, but the buyer's still in contract and the seller is still bound to the contract until the buyer can't perform. And then at that point in time, they can go, buyer didn't perform, we're terminating. 99% of the rights to terminate are on the buyer's side. The seller, once they agree to an agreement, they're locked in. And so this is one of those things you'd be aware of if you're working with a seller. Make sure you're happy with this and then that's why oftentimes a listing broker will push for a faster closing date, right? One, we want to get paid. I get that, but no, it's about making sure this is going to happen. So sometimes you get an offer and you want a 90-day close or whatever. You're like, wait a minute, I don't want to wait 90 days and find out you can't perform, buyer, right? That's not good for anybody. So Nelly, you're up. Nelly?
Sorry. I'm here. Actually, my case is under the buyer. I'm on the buyer side, and today is our last day for the option period, and we're back on negotiations for the sales price. And because my client works nights, so right now he sleeps, right? So we're like on a time of essence because the deadline for us to submit the termination is 5 o'clock, right?
Right.
So let's say, there's nothing that we agree. We don't have to send it to title, right? As long as we send it to the listing agent, we're good, right? If we decide to terminate.
Long as you have delivery to the seller, the listing agent.
Sorry, the seller. Yeah.
That's correct.
Got it. Okay. Thank you.
You're welcome. And you can also try to negotiate an extension if you want. You can say, hey, let's amend this and extend the option period because my buyer works nights.
Yeah. Well, this is our second time we extended.
Okay.
Yeah. So I think this is the final one. So I'm just trying to make sure, when I submit it, as long as I send it to the seller, we're good. The listing agent.
Yeah. And you're going to want to obviously follow up with title later and saying we've terminated the deal, just so you know. and then we'll send you a demand for earnest money coming up soon. So
Yeah. Well, I already gave them a heads up anyways, just so
Yep.
they know because it's Friday. So, okay, got it. Thank you.
you're welcome. Raul, you're next.
Yeah, sometimes we have well, we've been having more questions of agents that are on the listing side where if the seller has a chance or an opportunity to terminate the contract, and it could be simple as, I have another backup offer which is higher. I pretty much decided not to sell because it was a family matter. We're going to need the house back. So, and so we mentioned to our agents, what are you still in the kind of negotiating status or anything's coming along with the repairs or so, where if you have that cushion, maybe speaking with your client, the seller might not be in the position of helping, and it might maybe not entice, but maybe persuade the buyer to back out, right? So just but we have some occasions where the seller wants to maybe terminate just willingly, and of course it's not possible unless it comes from this option here. Yeah.
That brings up a very good question for our agents. You can unmute and let me know, but what is the one other way where a seller, let's say in Raul's situation where you're under contract and someone else comes along with a better offer and you want to take it, the contract doesn't allow you to unless you have one other addendum. What other addendum could you have that gives the seller the right to ask the buyer to go away, the first buyer to go away? Huh? Yeah, Nelly or Elva. Yep.
Elva.
Elva. All right. Well, a teaser. I know you guys know.
Wait.
Yeah. No. Yes.
The contingency form, is that the one?
Yep. For sale of other property. That's right. By buyer. Yep. If you've included, nice job, Elva. If you've included that, now in that status where you're pending, continue to show, they can negotiate that backup offer with the buyer, and then the seller then has the right to say, "Hey, first buyer, I got a better offer. You have 5 days to remove your contingency and move forward, or I'm going to the backup offer." And so there are rare cases, but that's one of those things where you can actually force the buyer to terminate, or get off the pot and move forward. So. That is the exception. Nice job. Yeah. And then we have one more handout. I think it was, where'd it go? Oh yeah, Thad. Go ahead, buddy.
Yes, sir. Good morning. So many years ago, I had a situation. I was representing the buyer. So we got to the settlement table, closing table, and the seller decided to opt out. Let me tell you the scenario. Husband and wife, they were going through a process of separation and divorce.
Mm-hmm.
Everybody signed. We went through the process, and on the day of settlement, we're already sitting down at the table. The wife, the wife calls the title company, claiming that she was bamboozled and threatened by the husband to sign all these papers. And that's why she signed the papers. But right now, she doesn't want to sign the papers. She was boo-ha-ha. I mean, she was hysterical. I'm representing the buyers. We're sitting on the table. We already signed our papers. And here she is, So the title company had to pull her aside, call the attorneys. And about 45 minutes later, the informer said, "You know what? We cannot go ahead with this because there's an issue here where the wife has indicated that the husband threatened her, and that's the reason why she signed the papers to sell the property." So now the wife is saying that, there's a threat, there's an issue involved, which might be domestic violence.
Mm-hmm.
They're saying this settlement is off the table. So I'm sure it doesn't fit into all this, criteria. Obviously, my face was in shock because I've never heard, seen, or even imagined that, that could happen. But that's exactly the scenario and the title company, I had to talk to the attorney, I had to call my broker, and all that stuff, so the attorney for the title company is saying, we are liable because the wife is now claiming
Mhm.
that the husband has threatened her. And since you have that situation, the signature was not informed. It was under threat.
You
So
may
we
not have a
cannot
valid
go.
contract. Yep.
Correct.
Now, I would still argue this. I'm glad you brought that up, Thad, because on the buyer's notice of termination, that paragraph 8 there, there is one other thing that's actually in the contract that gives the buyer the right to terminate, and that's when the seller can't perform. If the seller doesn't sign documents or cannot deliver a clean title, right? These are things that they've obligated themselves to do, to be able to transfer a title to the buyer in the general warranty form or whatever it may be. In that case, that I think number 8, if I was representing the buyer, like you were in that case, I'm like, all right, fine. We can terminate based on 8 and demand our earnest money back, or at that point in time. Or we can say, you know what, seller, I know, understand this is what's going on. Who knows, right? That's one of those things where it may be a thing where you may not have had a valid contract, but I would still go through the process and say, but buyer has the right to terminate because the seller can't perform for whatever the reason may be. So that way you're trying to protect the buyer's earnest money. Thoughts on that?
I'm thinking they'd probably say they didn't have a valid contract because they didn't have competent parties. Somebody signing under duress, not considered a competent party.
Yeah,
Don and Marty. That's because my buyers, I'm representing the buyers. They decided they were going to go to court. They're going to sue and all that. So the title, at the end of the day, the title company's attorney was like, our hands are tied. When you have a situation like this, where the wife, potential, they're going to be separated, is claiming that, she signed all this paperwork on the duress, even though we had a long period of negotiations and stuff, and everybody's signature was on. But at the end of the day, she said she was under duress, threatened by the husband, and that's the only reason why she signed it. So that's where we ended up with.
Yeah, and Elena said agreed. What's funny about it is be careful, everybody, and just even Don and I and Raul and all of us, we're not attorneys. We're conjecturing. Yes, probably wasn't a valid contract, but it's still a wife saying something that may or may not be true. We have to be handled out in the court of law, right? Because she may have signed it willingly at that point in time. But how do where that's not for us to conjecture. Bottom line is they couldn't sell, they couldn't transfer title. Buyer needs to walk away, and take care of his life again. So, yep.
I have a question. Can you hear me?
Yes, ma'am, Veronica.
We have a lot that we sell and everything was right until that we get a notice from the title company that they say they cannot proceed with this because they will never going to be able to have a clean title.
Mm-hmm.
So we decide to cancel everything. The seller decides, okay, let's cancel, and there's nothing we can do, cancel. We send the termination, everything signed. The only person that's refused to sign is the buyer. The buyer really, really wants the property. He knows that property, what he's getting is really for pennies because this works a lot of money. Mm-hmm. So he is now pursue. He said, I'm already have a contract, and this is Bali. I'm going to see my lawyer. He's in Chile. He's coming this Friday. And we have that issue with him. He refused to sign the document that we signed him to terminate because he said he don't want to terminate this deal. And I said, the title company, not any title company will do absolutely nothing on the legal way. So he said, I can hire a lawyer and I know we can take care of this because he really, really wants the property. He do not want to sign the termination. What can we do?
That's just it. The buyer has choices. Then the contract, seller can't perform. Same thing. You're on the seller side. Title can't deliver title. I get that. But still, there was a contract that said that the seller would deliver, whether they could or not. Since they can't, the buyer can take the earnest money, call it good. The buyer can sue the seller for damages, or the buyer can sue for performance. That may or may not be possible, but the buyer has the rights and they don't have to sign. So that's unfortunately, you've done what you can do. Now you have to wait for the buyer to make up their mind with an attorney or whatever. They may find it too expensive to pursue that, or the end result wouldn't be what they wanted. But there's nothing on the seller side or the listing agent side that you can do beyond that. Don?
So we already do everything that we're supposed to do. We send all the termination, the information for the earnest money to be returned to him. And this is where we stay right now. So we let the time go and let him to.
Yep. And
Even he cannot use our documents because if he's going to go to his lawyer needs to prepare whatever he needs to do. Correct?
our job is to recommend our client talk to an attorney as well. I mean,
Yeah.
that's it.
But nothing we can do at this point, right?
Nothing we can do. Yeah.
Take a
I
step
know.
back.
Have a
Yep.
wonderful weekend. Thank you.
You're welcome. It's the hardest part for an agent to do is to get their hands off. But post closing, disputes, we're not involved anymore. If our fiduciary duty is done, the legal disputes like that where we delivered our stuff, the notice has been delivered. After that point in time, whether it's signed or not, it's not up to us. I know it's tough. All right, so which brings me to yes, Catherine.
I just wanted to point out, I put it in the notes.
Yep.
If that was a catch deal, that wouldn't be as important. But if it's got a lender to it, that's going to be a big issue on the title commitment.
Yep. Yeah, for sure. And then, again, gives the buyers different options at that point, but it's not the seller that gets out of it at that point in time. So the best case scenario, Veronica, is if the buyer would sign it and just take the earnest money and go away. But they still they retain the rights through the contract not to. Yes, Misty.
If you're a buyer side and you are in your option period,
Juan Carlos Socio.
Hold
and
on.
you decide,
Go ahead, Angel. Sorry.
okay, buyer side, you're in option period, buyer decides they're not interested, you send over, the notice to terminate contract within your, by 5 p.m. or whatever. Is there any issue if the seller won't sign that? Is there any issue to get earnest money back, or the title will get the earnest money back to you whether or not seller chooses to sign the termination with you?
Misty, that's a great segue to the next section.
Yep.
So the answer is the seller doesn't sign the notice. So the termination is the termination. If the buyer sends the termination notice to the seller within their timeline, the deal's done. And then we deliver it to title and that the deal is terminated. Earnest money is handled separately. So we have this form, the release of earnest money form that then carries on that does require both buyer and seller to sign. And so you have a delivery of earnest money. You have a contract that says what happens to it in the event of default. We have different areas where the buyer has the right to terminate, very few areas where the seller has to terminate. So now that they've activated their right to terminate based on the contract. So everybody can see from a contractual standpoint, from a legal standpoint, that now the buyer has the right to the earnest money, but the release of the earnest money is typically handled by the title company and their attorneys. And they don't want to take any risk whatsoever. So they typically demand, that's why we have this form, both parties to agree on the disbursement of that, even though the contract clearly says buyer's entitled to it. And so what we see is most of them will not release it unless they have both signatures. So the form we use here says release of earnest money between the undersigned buyer and seller concerning the property at, you put the property address there. Very important. This is the big bold letters here. Says, notice the form provides for the release of the parties, brokers, and title companies from all liability under the contract, not just for disbursement of earnest money. Do not sign the form if it is not your intention to release all parties signing the form from all liability under the contract. Read this carefully. If you do not understand the effect of release, consult your attorney before signing. Then it goes on to say in paragraph A, the undersigned buyer and seller release each other, any broker, title company, and escrow from any and all liability under this aforementioned contract. You can see why someone may not want to sign this. Oftentimes a buyer, in Veronica's case, may not want to release earnest money or receive earnest money because they're waiving their right to sue the seller. Or the buyer may not want to sign it because they want to retain their right to sue vice versa, buyer, seller, whatever. This basically is a carte blanche, hold harmless to everybody that's involved in the transaction. So it's more than just directing earnest money. It is waiving your right to pursue anything else in the future, whether it be a builder or whatever. So oftentimes, both parties will often push towards this being done and handled. This is also why title will hold on to it until both parties agree to it, because it's such an important document and it does release them and brokers involved in this. So it's a big deal. But you've sent your termination notice on the buy side or the seller side, and now you want to deal with earnest money. Title is holding it. They need written instructions to release it. This is written instructions. This is what this form is designed for. And it has that additional provision that, hey, we're going to act like it's called a rescission. It's going to, if you sign this document and we disperse this earnest money back to the party you indicate, whether it be to the seller or the buyer or 50-50 or whatever the proceeds may be, and you both agree to it, it's as if the contract was never executed. Like it never happened. And the idea here, the whole harmless is all that stuff that happened never happened. We're moving on. So, you can't go back and be mad about something or sue somebody because your rights have been waived. So this is what that form is.
So what if they won't sign it?
Yeah, then they won't sign it. So then this is the next step. So let's say buyer sends termination and they have every right to the termination and the earnest money. Okay, I've sent my notice, in contract. Seller's already agreed that if you send the notice in time, they've agreed to give the buyer the earnest money back. It's in the contract. However, you're going to title and their attorney, you send, hey, buyer, or seller, here's my earnest money, or I want my earnest money back. Either way, your buyer saying, I want my earnest money back because I terminated within time, my contractual right. Or the seller saying, no, I want to keep the earnest money because you didn't terminate within your contractual rights. Either way. And the other party won't sign. We're at that point where we're talking about attorneys, because now they give you a period of time. Don, what's the number of time where title will hold it? It's a while, right?
Yeah, it's usually, it can be up to 7 years. It's usually not that long. It's usually a year or so, and then that's about it.
So at this point, Misty, though, you would say the seller won't sign the release of earnest money. You advise your client to talk to an attorney, because this title will not release it, but even though they have the contractual right to receive it. So you have to negotiate with the other side. And oftentimes attorneys get involved and fight it out to find some kind of resolution. And now you can facilitate by sending over, hey, we'll take half of it, whatever it may be. You can pass on documents and prepare those things. But otherwise, it's the attorney and attorney, because we're at this point in time, the deal's done. Our fiduciary relationship to our client is terminated along with the contract. Right there, we still may have a buyer agency agreement or whatever, but that part of this contract working between parties, we're not involved anymore. And so, unfortunately, there's no way to force them to sign it or force title to release it. And that's where attorneys could, based on the contractual language, send a strongly worded letter to title or to their attorneys and why it's in your best interest to release it. Who knows? But it's not our job to do that. On both sides, there's sometimes a seller will just be a jerk about it, and they just want to hold the earnest money up. And unfortunately, there's no repercussions to them because it doesn't hurt them, because eventually, whether it be up to 7 years or not, it's turned over to the state. So there's no resolution to it. That's at some point they should fix this. In California, Washington, Idaho, and I believe Alabama as well, the states that I've been licensed in the past as well, there is it's a fine timeline. There are 15 days to send notice of demand. There are another 15 days to basically come to agreement. And then after that, it goes into a judge where both parties have to go before a judge and plead their case. And it's decided right there. So it's like a 60-day process in other states. Here, it could be, like Don said, up to 7 years. So, but it's not our job to force the other side to sign it. You deliver it, as we said before. We've done our job. We can follow up. We can say, hey, buyer wants to do this or seller wants to do this. But title won't force it. We can't force it. Attorneys should be involved. Okay, lots of questions. First one, who's up? I think Elva. Elva's up. Yep.
Okay, if this happens, it's never happened to me before, but if it does happen and they don't want, one party doesn't want to sign, that means that the seller cannot sell because the money has not been released.
No. Now, yeah, this is one of those things that can be very confusing. It's a great question, though. So the first document you sent was a termination, which means the deal is done. Earnest money is being held, and it has to be dealt with separately. Okay. The property is now owned by the seller. There's no contract in place between buyer and seller. That seller can sell it. The problem we often run into is the title company holding earnest money doesn't want to open up a second transaction on the same property because they have this dispute going on. But it doesn't preclude the seller from selling it because they no longer have an obligation to sell the property because it's been terminated. The answer is no, they can still sell the property and then deal with the earnest money process later on. Problem is that many times they don't want to open up a second earnest money or on the same transaction, same title company.
Okay. Thank you.
Yep. Don, experience in that?
Yeah, a little bit. Yeah. I mean, that's what you run into. Sometimes, though, it does come down to who refused to sign the release of earnest money. If the buyer refuses to sign the release of earnest money, they may be trying to say that I still have equitable interest in this property, and things could come from that. But yeah.
Yeah. Now, obviously, if the buyer sent the termination, the deal's done.
Yes. Yeah.
If the seller sent the termination and the buyer doesn't want to sign it, that's a different story. Then if the seller terminates the contract with the notice and then demands earnest money or even releases earnest money and the buyer doesn't sign it, then the seller can't sell it at that point in time, just to be clear, because they're still in contract. There's a dispute over the contract being terminated if it wasn't done based on buyer's non-performance or non-delivery of earnest money. Buyer, though, terminates, the seller's off the hook. So and the earnest money is separate. So that's a great follow-up, Don, to that too. So make sure we're clear that there's always nuances. That's why we need attorneys as well. So Nellie, you're up.
I was just gonna comment, Marty. I don't think it's just not on the seller side, but I had a situation where we sent a termination and the release to the leasing agent, right? And she never acknowledged my email. She never respond, call, text, email, never. And then so I had to get the broker involved, because I was like, well, what's going on? Is she okay? Maybe she in the hospital, something might happen, right?
Right.
And then as soon as I called the broker, she called me right away. And she was very upset. She said, is this what your buyer was intended to do? And blah, 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 blah. So she was very, very upset. And she signed the release, did not sign the termination though.
Oh, you don't have to sign the termination. Termination.
Something. There was one that I don't know what form is it, but there's one that it doesn't need to be signed by either or, and she only sent one form, and I'm like, okay, well, but she was very upset because we sent the termination letter.
It happens. It's okay though. We're following it and advocating for our clients, so we're good. Yeah, Marie, you got a comment? Question? Down there in Harlingen.
Can you hear me now? Can you hear me now?
Yes, ma'am.
Good morning. Going back to the previous conversation on the title,
Mhm.
and they hold the earnest money, that you can always go with another title company.
Yes.
Another title company would be your first option because it's going to be a different contract, different transaction with the different buyers. Am I correct?
You are absolutely correct with the one provision that we came up with later. If it's the seller that terminated the contract with the buyer and they didn't have contractual right and the buyer wouldn't release it, you may have a clouded title based on the buyer's right to buy that property. So opening up a new title would not do well. But if the buyer had terminated that contract, you're right. Absolutely. And choose any title company you want, start a new transaction, you're good to go. And just make sure that you're clear on what you're trying to do. You're not trying to evade a sale and having something bite you later on, like selling the property twice. So, yeah. All right. Page 2 of this is one of those forms. I think it's very interesting because it requires both the buyer's signature, the seller's signature, and the agent's signature. And I've seen these come across without the agent's signature many times as well. Yeah, this is where we're involved saying, all parties are saying, because it's a release. Remember, the top of the form said we release all parties, brokers, title company, buyer, and seller. So since we're part of that being released, when we sign it as well, we're releasing our right as the brokerage to go after the other broker as well. And so is the other broker. So you got to understand, this is a very legal form that's oftentimes is disputed, and for good reason, because of the release factor, removing the rights to pursue damages or performance or whatever. And that's why once we deliver this and the other party won't sign it, we ask our clients to talk to an attorney. All right. I saw one more. Elena? Yeah, Elena. And some agents do not sign it. Also, signatures do not have to be on the same page. That is correct. Yeah. What is that called? It's, you can have this document twice. I can sign
Duplicate originals.
Thank you. Yeah, you can put them together. They're agreeing to the same terms on two different documents, and you're good. But to Elena's point, this is important, of signing. And so often we'll see it. Hey, buyer, agent, you need to sign this as well. So, before to me it's ratified. Oftentimes title we'll be looking for it. And the mention about when you couldn't reach the other agent, calling the broker is a perfect example of that. Even if that doesn't work, oftentimes you can say, here, title, we have our side signed the release of earnest money, whether it be to the seller or the buyer. Can you reach out to the other side as well on our behalf? Maybe they'll sign it for you. That's about the extent of what we can do.
And sometimes it makes easier because the emotions are there and they really don't want to see each other's signatures anymore. So
Right.
I found out that it's easier sometimes if we get two originals, one from the buyer side, one from the seller side, and cooperate with the other party because again, we don't know what the listing agent is going through or the buyer's agent going through. So I find out sometimes that it's easier if I just have two originals and that's it.
Yeah, it could be. That's a good example or good advice when you're having a problem with this. To the point where that's an extra level, but you're still advising your client to talk to an attorney if there's any kind of like what's the word? Where they won't want it. Hesitation. That's where hesitation. If there's any hesitation where they won't follow through, I know your buyer's gonna be frustrated. I know the seller's gonna be frustrated. Yeah, and you're frustrated, but this is one of those things where we've done our part. The other party still has the right to sign or not sign. And sometimes you can come to a happy medium eventually, realizing that you're not coming to an agreement. Like, how can we negotiate this at a point where we move on together? So, Dawn, you want to wrap this up? Raul as well, Elena, go ahead.
Well, go ahead.
Sorry, I wanted to mention about what Don said about, sometimes buyers and sellers, they wait to sign this form. I had a buyer that disappeared. She signed the termination of the contract. It was a horrible deal. And the seller signed, she signed, but she never signed the release of earnest money. Mm-hmm. They all agreed, but she disappeared. She didn't answer. I believe I was representing the seller. She disappeared totally. She was unrepresented. She appears out of the blue 3 years later, calls me screaming 3 years later that she never received the earnest money. And I was like, well, this is the form. I have copies of all the emails. It was sent to you. It was sent to title. 3 years later, she finally signed up that form and took it to the title company to get her money back. I was like, I could not believe it. It was a horrible deal, but she got it 3 years later.
There you go. It's going to be sitting there until it's turned over to the state, as Don said. So yeah, Don, want to wrap it up? And then Raul. Next week, Raul's going to cover the letter and intent. On all commercial transactions, we typically start off with a letter of intent, which is basically saying, hey, here's the terms we're proposing to make in a written contract. Now, let's come to terms on the basis. And then once we come to terms here, then we'll write the contract with the terms we agree upon. It's a quicker way of negotiating, especially in commercial. So yeah, Don?
Sometimes I wish we had that in residential.
Yeah.
Really, all we have to remember who the title company is here. Title company is a neutral service provider, and they cannot show favoritism to either side. And so it may seem perfectly logical to us and to the buyer that I'm walking away during my unrestricted right to terminate, during my option period, which there shouldn't be any question as to whether or not I should be getting my earnest money back or not. So I don't understand, why do we have to fill out this release of earnest money when I'm walking away during a time when I have this unrestricted right to terminate? Well, for the title company to just go ahead and release that money at that point without the release being signed, it's the title company trusting that the option fee was delivered in a timely manner, that it was the right amount, that the effective date on the contract that we're working from was correct, that they really are within their option period. So you're saying that the title company is just trusting all of that But the title company works from trust but verify. And since they're working from trust but verify, that earnest money release has to be done no matter what the reason is for termination, whether it's buyer side, seller side, even if it seems perfectly logical to us that there shouldn't be any question, the title company has to question it. So that's it.
Yep. Thank you. That's perfect. Way to wrap it up. Raul, do you want last words on this?
Yes, and also great both of these forms, especially the release of earnest money, and it comes almost in the human side or humanistic side where you get more bees with honey, and it comes where you get to that point where it might escalate something personal between both sides, and then the earnest money is not released or just missing some signatures from either side. So it's a matter of coming into agreement, sometimes half and half, maybe 1/4 to one side, 3/4 to the other, instead of the money staying there for months or for years. We're in a situation right now, the agent calls us where there's a $2,800 release, and the buyer, actually the seller's not signing because it does belong to the seller. After the total review of the contract, the money does belong to the seller. The buyer says, I deserve half of that. The seller says about the principal, I do need it all. And it's just sitting there. So buyer says, I'm down to maybe just keep 1/4 of that. You keep 3/4. So both agents are kind of negotiating that. It's just one signature needed, but instead of staying there, it might just have to maybe see it from one side to make it happen. So yeah, it's about coming into an agreement even up to the end.
And sometimes that is more about saving your relationship with your buyer to move on to the next property, or your seller for that matter, and saying, I've done my best. We're negotiating. The best case scenario is, when they don't have to agree, can we get them to agreement? If not, it's attorneys fighting it out. And when you go that route, oftentimes your relationship suffers as well with your client, just because it went that far.
Yeah.
Angel and Jose, you get the last 2 words.
I just have a quick question on what the rights are if you're going the morning of signing, you're doing your final walkthrough, and there's been damage or something to the property, that the property is not being delivered to you in the condition that it should be. What is your right, and what form would that be to walk away?
Yeah, that's a great question. I'll have the other brokers chime in as well. Contractually, the seller hasn't performed. They're supposed to deliver the property in the same condition it was when they made the offer. The walkthrough, you find out, was not. There is damage. So the seller now would be in default. So obviously that would be, you would try to extend the contract for the seller to cure it. There's language in there. The seller has the right to cure it, make it right, whole, through the extension. And if they can't restore it back, that's a different story. Then the buyer has the right to terminate at that point in time. It's not an automatic, hey, you didn't do this, I can walk away today. It's like, seller, you haven't performed. Let's extend the contract to allow you time to perform and get it in the condition it is. And the seller, if they don't want to do it or can't do it, then you can walk away.
And it would be the one
Yep.
the one about seller's non-performance.
Yeah,
Like
that would
say
be
they
the last.
trash the property, angry seller trashes property.
Yes, the last paragraph there where it says the seller must deliver it in the same condition it was. That's where you would reference that paragraph and the reason why the buyer could terminate. Yep.
Okay, thank you.
Mm-hmm. We had Jose. Where'd he go?
Angel.
And I think we lost him.
All right. Well, all right. He's like, I'm going to stop recording. This has been a great conversation. I love all of you. So, gentlemen, thank you.